good evening. No, I'm just used. Good day. Good afternoon. This is Dr. John Bennett from Miami, Florida. We're having a live hangout with Nicolas P. Terry, an attorney from Indianapolis, a friend and associate of Paul Sotek, the doctor that's running the conference, that started the conference. And Nicolas deals mostly in M health issues. And today we're going to have an informal discussion about M health, and partly with Google Glass. Nick is talking at the conference on, I believe, Friday, and we'll try not to repeat too much stuff that he's going to cover in the conference. But okay, Nick, I guess I'll just start off saying thank you for taking the time, and basically, I guess introduce yourself and talk a little bit about what you feel you want to talk about with Google Glass and legal issues.
Sure. I'm Nicolas Terry, at Nicolas Terry. There's no H in that. And I'm the Hall-Render Professor of Law at Indiana University Robert McKinney School of Law here in Indianapolis. I'm also the Director of the Hall Center for Law and Health. We have one of the largest health law programs in the country, educating JD, LLM, SJD, and joint degree students. My particular areas of research, where I do a lot of my teaching, is in health quality, health safety, and health information technologies. It's pretty much a natural to do that here at IU in Indianapolis, because sort of over my shoulder is the School of Informatics, the School of Medicine's down the road a bit. We've got the School of Public Health, and bioethics is a little just around the corner. So there's a lot of great interprofessional work going on here. So I've always been very interested in the impact of technology on law, because technology is intrinsically, particularly information technology, but most technologies are intrinsically disruptive. And the legal system, as many of you know and many of you dread to know, tends to move very, very slowly. So you usually get a nice juxtaposition when you throw highly disruptive technologies which are moving, which are iterating very, very quickly at a legal system that seems mired in several feet of sticky mud. So there's usually lots to talk about and lots of interesting sort of dynamics there to play with. I guess I started looking at M health back in the days when we thought it was all going to be done on the internet, and before the great problems with internet prescribing and everything kind of sort of slowed all that down, and sort of got involved early on in some of the questions about legal advice, I beg your pardon, medical advice appearing on the web, its reliability, and so on. And then I've just kind of stayed with the subject as we've moved through the HIPAA stuff in late 19s to 2000, then into obviously the time of HIPAA privacy, clinical data sharing as it's been viewed as a priority by the federal government, and with the HITECH Act, and now watching even more interesting phenomena develop, such as big data and mobile health.
Huge field.
It keeps me busy.
Yes, yes. You know, I'm sure next every doctor, you know, when they hear the word HIPAA, it's like electroshock, and everyone is kind of scared. And I think a lot of it comes from basic ignorance. Could you briefly just describe the broad overview of what HIPAA is and what it's designed to do?
Yeah, actually, HIPAA is incredibly simple. The barriers to understanding it are the fact that sort of nowhere in the HIPAA regulation is there a sort of a cheat sheet. You know, the 5 sort of big principles that we're going to base HIPAA on. They leave you to figure that out for yourself, and they just get straight into the regulation. The combined regulations now run almost 200 pages. It would help if they were written in English. They're not. They're written in a strange language only understood by people who work in the headquarters of HHS in Washington, D.C. So, all right, so the simple version of HIPAA. We've taken the approach, rightly or wrongly, that we think health information should remain exclusively within the health space. We've taken the approach that you, as my doctor, God help both of us, John, you, as my doctor, need certain information to diagnose and treat me, and I have an incentive to provide that information to you to maximize my chances of success at your hands. And so traditionally we've been able to make a deal that I'm going to exercise my right of privacy and give information to you, and in exchange you're going to promise to keep it to yourself.
Okay.
And that's the sort of traditional physician-patient relationship deal that we've always made.
Okay.
Now, that gets a little more difficult when we sort of enter more industrial models of healthcare. I'm no longer dealing with Marcus Welby here, who's popped round to the house with his little bag.
Right.
Instead, I'm dealing with a sort of a massive industrial medical complex. But we still take basically the same approach, that if I give my information to a traditional healthcare provider, a doctor, a hospital, for example, then I expect them to keep that confidential. And that's basically what HIPAA says. Now, to achieve that, HIPAA sort of says, okay, so this thing in the middle where we want this health information to sort of stay, let's call that the green zone, right? The medical zone. Although we do a little business in there as well, because we've got health operations and things like that. And then everything that's outside of that health domain we'll sort of call the red zone.
Okay.
So we want the information in the green zone, but we don't want it out in the red zone. So we'll separate the green zone and the red zone with two walls. The first of those walls we call the privacy rule, and that tells the people who are inside the green zone, like yourself, hey, you've got confidential information, don't be trying to push it out into the red zone.
Okay.
And the second sort of wall we build around the green zone is a security rule. And the idea of that is that the people in the green zone make up sufficient strength in that wall to stop hackers coming in and getting information and pulling it from the green zone into the red zone. So we have a couple of different things. We're trying to stop a push out of the green zone into the red zone, and we're trying to stop people coming from the red zone into the green zone and grabbing our information. So that's the basic idea. The model starts to break down a little bit because for the last 15 years since the HIPAA regulation was passed, we've never been entirely comfortable about the size of the green zone. Health information seems to whiz around the green zone for purposes and to parties way beyond the treatment team, right? And so we're not entirely sure that therefore that old deal that we had, I'll give you the information, you'll look after me, whether that's being respected in these larger enterprises. The other thing is that there are a lot of people in the red zone who say they've got a claim to the stuff that's in the green zone. And so HIPAA put a lot of exceptions in. So, for example, public health authorities can get hold of information. The legal system can get hold of information. In some limited cases, people doing marketing for hospitals can get hold of information. I can even give consents to other people to get hold of information. Well, anytime you have these, if you can imagine, now I'm torturing my analogy even more, my red zone. If you imagine sort of, these are faucets, right?
Yeah.
That allow stuff to drip out from the green zone into the red zone. Anytime you have these kind of structures, you can get function creep. or you can get unintended sort of leaks. So stuff every now and again will kind of sort of filter out of the red zone when we don't want it to. So that's really been sort of the HIPAA model. It's, as I say, extremely cumbersome for healthcare professionals. They don't really understand it because no one's really ever taken the time to explain it to them.
Yeah.
It seems to involve more pieces of paper than it does principles. You know,
Yeah.
I think as professionals, we're good at understanding what's important and the principles that guide us. But we get kind of impatient with lots of pieces of paper and rules that don't seem to map to principles that we can understand or have time to understand. The other thing that's so important, of course, is that the table stakes are very high here, particularly since the High-Tech Act was passed in 2009. Enforcement of HIPAA has become considerably more robust, and we're seeing, you know, quite significant fines now placed on healthcare providers, on folks supplying them services, all sorts of things. Sometimes you look at what these folks have done and just shake your head like, really? You thought it was okay to do that? Never mind what HIPAA says. You thought that would be a good way of running your business. And other times you see people just kind of in a big bureaucracy kind of getting trapped into sort of some not particularly good practices and finding things going badly. But, you know, we've seen a lot of big fines. Two of the New York hospitals who were doing a data sharing thing just got into almost a $5 million fine between them a couple of months ago. And what happened there, as I remember the story, not exactly, so apologies, but basically they were involved in a joint venture with regard to some data sharing or something. And one of the physicians who was working there was doing some software development or something. And in the course of unplugging one of his servers from one of the hospitals, it apparently opened up a big hole and everything gushed out. And so, you know, there you have no doubt an entirely innocent physician trying to develop some new stuff, and a major crisis for those two institutions, and big penalties, and those penalties also will tend to be on top of an agreement with the government on a new sort of code of conduct, which we call compliance, on how they're going to change their practices and report back and stuff like that. So it all gets very expensive. So that's why folks are taking it very seriously.
Mm-hmm. Well, you know, Nick, one of the things, the concepts I have a hard time sometimes wrapping myself around, I think a lot of doctors do, is the educational aspect of medicine, because as you know, there's so many new techniques, there's new ways to educate, and sometimes it goes from what you call, which I think is a good analogy, the red and the green. It goes from the red zone into the green zone, trying to promote education. Do you understand what I'm saying? Where the physicians or the educators will say, well, what do you mean this information is it's anonymous almost, it's data. Well, why can't we have access to it? Do you know what I'm saying?
Well, I think there are various interests sort of pulling at this data at the moment. It is clear that the amount of clinical data that the U.S. healthcare system is generating at the moment is a great source for research.
Yeah.
And that is research that maybe would be intramural by NIH. It may be commercial. Equally, it could be people like big data brokers, all of whom would like a little piece of this, or in case of data brokers, a very large piece of this.
Right.
So there are a lot of calls on the data that's flying around. There is also sort of the educational component, as you say, and that itself probably needs a little expansion. In that, are you talking about just educating physicians? Are you talking about educating young physicians, medical students and residents as they come through. And to a large extent, we're talking probably today and tomorrow about educating the public about medicine. So there are lots of strands of this as people want more and more access to data. The old idea of de-identification of the data, while it's still basically the default rule in HIPAA, because basically HIPAA doesn't apply if data has been de-identified.
Yeah.
All right. HIPAA only applies to personally identified
that was a question
health information.
Yeah.
So typically, if it's de-identified, you're not going to be looking at HIPAA problems. On the other hand, it's getting increasingly easy to re-identify data.
Okay.
So that sort of seems to be the next sort of big hurdle, and one of the real problems we have, for example, with big data getting hold of any kind of medical information because of the relative ease big data algorithms have for re-identifying information.
Right. Yeah, that was the area where, well, sometimes it's obvious whether they'll mention, a doctor won't mention a patient's name, but it will mention the age and their diagnosis and almost where they live in like a local type of column. And I guess that doctor would be liable because it would almost be obvious to the local people who it was.
Yeah.
People knew, you know, but in case of big data, where there's thousands, millions of names, and yeah, one thing I wonder if you might comment on, Nick, is I'm sure you're aware of Google not wanting to get involved in the or having trepidation about getting involved in the medical space because what they consider excessive regulations and rules, which they said flat out. Larry Page at one of the conferences says, well, we really don't, we think medicine's over-regulated. We think that big data can do a lot of good, but health is not letting us in. Can you comment on that, Nick?
I think there are two things. There's always the over-regulation meme, right? I mean, there's always innovation is being stifled by over-regulation, and one person's over-regulation is another person's under-regulation. And somewhere we have to find the sort of the place in the middle. There shouldn't be. It's a false dichotomy to say all data should be free, just like it, and it's false to say that all data should be locked up tight and no one ever gets to see it. We have to figure out where, as a society, we want the sort of the middle ground to be, and we also have to figure out the choice architecture for patients as to exactly what kind of role they have in making that decision about their data. So that's a complex question and can't be just reduced to all or nothing. The other thing I think about Google is the way the data is being presented. Google got burned with Google Health.
Okay.
All right. And what happened to Google Health was the High-Tech Act, which brought in the subsidies for meaningful use of health records. And the technologies that the government decided to subsidize are sort of last generation technologies. They're not in the kind of data format that Google can deal with them. They're sort of proprietary. There are a multitude of different electronic medical record formats and providers. And so I think Google's always had a problem with the format that health data is presented in. They have not been able to get to it and do the many wonderful googly things they do, even though you then have to say, yeah, Google, but we remember, please, no evil. So we, you know, there's that point. So I think they've had a tradition of sort of hitting their head against the sort of what they view, and I'm putting words into their mouths, I'm sure they may well disagree, but them hitting their heads against the wall of what they view as sort of a rather archaic form of data storage and data formats. then they plug the additional question of what they consider to be over-regulation on top of that, and they don't see a lot of opportunity at the moment in really sort of doing something disruptive and interesting with healthcare.
Do you think the rules will change with HIPAA? Do you think HIPAA will be changed because of the pressures of digitalization and demand for more data, demand for more access from companies like Google or whatever, the general public?
Well, it's interesting. I mean, at the moment, I think the accepted, maybe not at Google headquarters, but sort of the accepted sense around healthcare at the moment is that, if anything, the privacy rules need to be tightened. And the reason for that is because there is now so much medical information being generated outside of the traditional health domain.
Mm-hmm.
So I've done quite a lot of writing about, for example, how big data is able to sort of basically almost ignore the HIPAA protection, because it can access medically inflected data and stuff that's leaked out of HIPAA and stuff like that, and quite legally sort of construct a medical profile about someone without ever running into the HIPAA rules.
Okay.
You know, the classic tale of that, if you remember, was that great New York Times Magazine article of a year or two ago about Target and the way they were able to figure out when women were pregnant. Because of their changes in their buying habits. They would change to unscented body lotions and stuff like that, and then be able to target them with ads, no pun intended. And so all of that is it's not traditional healthcare information like your manila file or folder would be on me, you know, with a fly sheet and then vitals and stuff like that. But for those in marketing and those trying to do market segmentation, that data is roughly the same as is the stuff that's within traditional healthcare. Yet at the moment it's completely almost completely unregulated.
Mm-hmm.
So if anything, you know, we need to maybe tighten things up so that it's not so much that we need more regulation of the health data that's in the traditional green zone, the health domain. We need to make sure that health data that's operating outside of that area is equally well respected. The other area where, other than big data, where this comes into play and a direct relevance to what we're doing this week at the Watch Society conference is when you look at mobile.
Mm-hmm.
More and more, sort of the quantified self, the mobile health apps are going to be containing data that medical data, health data, that is not being entrusted to a HIPAA-regulated physician or hospital, but essentially is being curated either by the consumer patient themselves or by a cloud service that is linked into the mobile device. And, you know, is that health information any less important than the health information, back in my example, that I disclosed to you as my doctor? Yeah. Some of it's going to be equally as valuable, equally as important, equally as sensitive. And yet, under that current law, it's quite difficult to identify the appropriately strong legal protection for that.
Yeah, there seems to be kind of a wavy line between what is a medical device and what is not. I think that's what you're talking about. What does, you know, you know, a certain device can collect health type data, but it may not be considered a medical device, because I know for a device developer, that is a big distinction, because obviously there's more regulation. If it's FDA defines it as, wait a minute, this mobile app is a medical device or an application, we have to regulate it. And I'm sure there's a little tiptoeing around the line there with some people that make apps and devices. Would you say? Shifting gears a little bit.
Before you go there, I need to unpack that a little bit for you, because the FDA makes decisions about medical devices.
Right.
All right. And we know from the September 2013 guidance on medical devices, we know that the FDA has sort of said, well, we think there are like 9 categories of mobile apps, and we're basically going to regulate 3 of those categories, and we're kind of going to leave the other 6 just to sort of develop and see what happens. Now, whether the FDA applies device regulation or not to an app or to a plug-in that fits into your lightning connector of your phone or whatever, that's got nothing to do with privacy.
Okay.
Security. All right? The FDA is looking at this from the perspective of safety. They're running risk analysis with regard to those devices, to see those apps, to see whether they have sufficient risk that they need to be regulated for our safety. That is quite distinct from the privacy issue. FDA doesn't touch that. And whether or not something is a device is not determinative of which privacy rule applies or which kind of privacy law applies.
Yeah, I guess I kind of snuck in another issue there. It's the issue.
You snuck in another issue, sir.
Guilty. Well, you know, I know that there's a fine line of when does a device have to be regulated? When does it? I guess the true determinant of whether or not it is if a patient makes a decision, or that data generated forces a patient to make a decision, like a medical decision. It's taking. I guess the bottom line is it's taking the decision out of the hands of the doctor, who takes that data and makes a decision. It gives the patient the data to say, okay, this is a decision you should make. Is that
yeah. So if you go to the FDA's guidance and you look at these 9 categories, and you say, okay, what are the 3 categories that at the moment they're really going to be looking at? And the first one is pretty obvious, and that is that it's sort of mimicking an existing medical device, right? Yeah. So, you know, the obvious example would be the blood pressure cuff or something like that you plug into your phone. Or maybe as the phones get better and better and you look at that little M7 coprocessor that's in the iPhone 5S, you know, and its continual monitoring of all the onboard sensors, maybe you don't even need to plug stuff in anymore. Maybe these phones are going to be so smart, they're going to be able to monitor our blood flow and listen to it, for blood turbulence and stuff like that, and so on. So all of those things are sort of mimicking an existing medical device. FDA has no problem saying, yep, if you look like a medical device, we're going to regulate like a medical device. And I don't think any of us would have too many problems with that. Yeah. The second kind of thing that they're going to regulate is really inside your space, inside the hospital. It's inside baseball. It's if you're looking, you know, if someone builds an extension to an MRI so that you can actually, in your office, you can read the MRI report on your pad or something. So it's like an external monitor that's built in. Again, you know, that's very close to an existing regulated medical device, so they're gonna have something to say about that. The third category, I think, is the one that you were referring to, and it's the really interesting one. The third category, and I can even tell you exactly what it says: mobile apps that become a regulated medical device by performing patient-specific analysis and providing patient-specific diagnosis or treatment recommendations. And it's like if you were to take one of your decision support systems, right, running on the hospital backbone and tied into the EMR and the CPOE and everything, and you were to turn that into a consumer-facing piece, such that not only is it monitoring me and watching what I'm eating and my weight and goodness knows what else, but it's then all saying, hey, Nick, you know what? If you want to live to do John Bennett's next hangout, you need to stop eating that. You need to exercise on Tuesdays, and a few other things. Now suddenly we've moved out of the realm of playing games with our phones as to how many steps I've taken today, right? Because of my Fitbit or whatever, and we have this mobile app actually making a sort of a treatment recommendation, and the FDA says that's got to be regulated like a device. The difficult thing is that's actually the one we want, isn't it?
Yeah.
That's actually something that would be useful, as opposed to sort of the relatively useless kind of stuff that we have at the moment and we're going to see for the next couple of years. We are going to get so bored with trackers and apps on our phones telling us how much caffeine we're drinking and who knows what else. What we really want is something that's going to help. So there you have that nice clash, right, between regulation and what consumers actually want.
Yeah, a lot of data is going to be out there. Tons of data. Hopefully, doctors will still be around to interpret it, and they won't. Some people say doctors will be replaced by computers that make the decision, but I don't foresee that. I hope you don't either, Nick. In a couple of years, until I retire.
You're all going to be living very comfortably in the cloud.
Good. A couple of issues I want to delve in just before we let's get away from him for a second. And one question is particular to this conference. You have the Google Glass, the shape of the Google Glass, and I don't know if you're going to cover this in your talk. The shape of the Google Glass. How much can a doctor modify that shape? What can he do and can't he do, essentially? Can he, I guess, copyright, they probably have something copyrighted, and you can't do certain things to it. Is that true, or you can do what you want?
Well, generally, once you buy something, you can hack at it.
You can do whatever you want?
I mean, if I buy an iPhone and I decide that one night I'm going to unscrew it and replace the camera with a different camera lens,
right?
I think there would be guffaws of laughter from Cupertino that I would set out on such an endeavor, but Apple aren't going to stop me doing anything unless, of course, I start trying to resell the modified iPhones or something like that, and then intellectual property comes into it. So actually modifying these things, I'm not sure is terrible or particularly problematic. You'd have to ask the Google attorneys about that. They very much are taking the position at the moment that Google Glass is, at least they're taking the public position, that Google Glass is essentially a consumer or recreational device rather than a medical device. We know that folks are modifying Google Glass, typically with software, to do things like turning the camera off and to change how Google transmits to try and make it only transmit over encrypted and therefore HIPAA compliant networks and stuff like that. So I'm sure that will go on until maybe Google itself turns around and says, you know, we're going to make a HIPAA compliant version of Glass. I'm not sure about that.
I guess we'll see. You know, one question I've run into, or actually I brought it up with some doctors, because in the last couple of weeks, Nick, I've been talking to doctors in all different specialties about Google Glass, and each particular specialty will have its own uses for the glass, and we've even talked about with some doctors about changing the structure, because they were wondering, well, can I put the camera here? Can I do this and can do that? But it does make sense when what you say about you can make them, but you can't sell it.
Right.
Yeah, so that seems to make sense. So it kind of.
We also know that Google itself is now entering into relationships with eyewear manufacturers and so on, and actually are offering different designs. So presumably there will be opportunities in the future for you to buy one with the camera on the right rather than the left, or on the bridge or whatever. But I mean, the most important thing about this is so early.
Yeah.
I mean, are we really going to be having this conversation in 2 years' time about Google Glass? Or will of all the technologies in Google Glass have been replicated on a contact lens?
Yeah.
I mean, this is so early in the development of that software, of that hardware.
Yeah. I never thought we'd see desktops outmoded. I mean, but essentially everything's going mobile.
Right.
I kind of like the desktop, but it seems that most people now do lots of work on iPads and mobile devices and stuff. But and one quick thing before we go, Nick, about telemedicine. I guess there's a in Congress in November they're going to bring up about telemedicine being or a doctor having a national license to be able to prescribe to anybody in the country. Do you have anything to do with that? You heard about that at all?
Yeah, I think actually it's going to be tough for the federal government to actually bring in a national license, even though I would actually favor that, because I actually favor national licenses for lawyers, and I favor national licenses for doctors too. But legally, it's kind of tricky to do that because the states constitutionally probably have the rights with regard to that. But I think what Congress is going to do is facilitate and encourage cross-licensing. So basically, your license will be good wherever you go, or something like that. Or it would be very easy for one state to recognize another state's license. And as soon as that happens, and as soon as there's not a financial penalty on having multiple licenses, that should open the door for a lot of telemedicine. But like most things in American healthcare, it's where the money is.
Yeah.
If there is good remuneration, reimbursement for M-Health, for telehealth, for treatment across state lines, then I think various lobbies will get together and push through the legislation that is necessary. Telemedicine is so overdue for this; it's almost criminal. So hopefully something will happen this coming year.
Yeah, I just heard from an agency. It's called CallMD. That's an agency where a doctor does actually telephone consultation, but it has to be within your state.
That's right.
I just got an email from them saying that they're instituting now a video call service, which I think probably they're pushing towards. Of course they'll go national, but I think they're going to still limit it to video call, but it's got to be within your state.
That's right. That's right. If you compare that to, for example, it's not terribly hard to run a national pharmacy business. Because it's relatively inexpensive to get a pharmacy license in many different states, and so you can be quite legal, if you're drugstore.com or something. I'm not talking about the folks out on those little islands off our coasts doing naughty things, but for real legal businesses, they can get multiple pharmacy licenses for their pharmacists and act across state lines quite legally, and we need to move healthcare services towards that. People want 24/7 care, and one of the ways we know from IT to do that is to have folks in different time zones who are prepared to offer those services.
Yeah, well, there are certain areas of medicine. Teleradiology has been around. I'm surprised to hear about doctors reading X-rays from other countries.
That's been a big business in Israel, Australia, India for a few years now.
Yeah, but America, does that apply to America too?
That's where that's where the scans are coming from.
Yeah.
Those Nighthawk services, as they're sometimes called, or I think that's actually a brand name for some of them. basically they enable the first read of a film overnight when perhaps when there isn't a radiologist on duty in the hospital in which the scan is taken. Then there'll be a second scan, a second read the next day, and that's what triggers the reimbursement. So yeah, that's a really interesting area. The other thing that's getting really big is remote ICU stuff. There's a lot of interesting stuff in that space as well. So I think there's there's IT that's going to be really interesting, and is interesting in the traditional healthcare space. And the question is, which is going to gallop faster, that or this new mobile stuff? And I think the mobile stuff has probably got the legs on it, and is where we're going to be spending most of our time in the next decade.
Yeah, there was an exciting possibility the other night. Albert Huang, the Methodist Hospital in Houston, was talking about using Google Glass in the ICU, and maybe there'll come a day where patients will be checking from another state on a rural ICU what's going on with the patient, because he was saying that it helps the doctor that's going to be at home, because typically he gets a phone call and he can't see the patient, but something like Google Glass will allow him to see it. Anyways, Nick, thank you very much for taking your time out this afternoon to talk, and I hope we cover some good legal issues.
Good, and I hope people come to the conference. It looks like it's a great lineup. You're going to be there, you told me. And
yes.
We got some wonderful speakers.
What time are you speaking?
I'm at 1 p.m. on Friday. And my topic is Google Glass, legal and ethical issues in the surgical suite.
Very good, Nick. Okay, we'll see you then.
All right, cheers, John. Thank you.
Thank you, Nick.